Good evening, everybody. Welcome to the Royal Society. My name is Julie Maxton, and I'm the CEO here. This is the 11th in Cara's series of Science and Civilization. This is a series that brings together leading academics, writers, philosophers, and other renowned public figures to discuss important questions relating to academic freedom. As many of you will know, it takes its name from a lecture given by Einstein in October 1933 at a major fundraising event on behalf of Cara and 3 other organisations who had come together as the Refugee Assistance Fund to help those being expelled from Germany by the Nazis. The Royal Society is delighted to partner with Cara. Cara does vital work in ensuring at-risk academics can seek refuge from violence, conflict and persecution, and reach a place where they can continue their work in safety. The Society believes that academic and scientific freedom are essential for the pursuit of excellent science for the benefit of humanity. Our 2020 statement on academic freedom sets out the Society's position and emphasises our commitment to academic freedom generally. We act to defend researchers through our continued membership of the UK and Ireland Academies Human Rights Committee, a consortium of UK academies which advocates for the freedom of for academic freedom and individual rights of researchers under threat. We also collaborate on individual projects designed to support researchers in particular contexts. However, as you are all no doubt aware, these are challenging times for academic freedom. All around the world, increasingly authoritarian regimes and political movements are putting increasing pressure on already at-risk academics. Ongoing conflicts across the globe are having a devastating impact on all those unfortunate enough to be caught up in them, including academics, scientists, and the education sector as a whole. Even in countries considered democratic or peaceful, ongoing political tensions can make it difficult for academics to work freely. Increasing distrust around science, fueled by misinformation and a lack of scientific knowledge, can make the life of an academic suddenly perilous, even for those working within the least controversial of professions. I'm thinking, for example, of meteorologists in the US who recently received death threats from members of the public convinced that the recent hurricanes which have devastated the southeast were man-made, which echoes similar aggression faced by infectious disease researchers and science advisors during COVID. Within this context, it's of great importance to the Society that science is properly understood, and not just by those who practice it, but also by decision makers who use science to inform their choices. A lack of scientific understanding can lead to serious miscarriages of justice, such as legal decisions which place too high a value on eyewitness testimony or that are based on misapplied statistics. For these and other reasons, the Society has established a Science and the Law programme which brings together scientists and members of the judiciary to discuss key areas of common interest. When properly understood, science can and should help secure justice across jurisdictions, as although legal frameworks differ, science is universal. With this in mind, it's my privilege to welcome Philippe Sands to the Royal Society. Philippe is a Professor of Law at University College London and a founding member of both Matrix Chambers and the Centre for International Environmental Law. He's the author of 17 academic books on international law, including Lawless World and Torture Team, which investigated, respectively, the legality of the 2003 Iraq War and the use of torture as an interrogation technique in Guantanamo Bay. His book, East-West Street, on the origins of crimes against humanity and genocide, won the 2016 Baillie Gifford Prize, the 2017 British Book Awards Non-Fiction Book of the Year, and the 2018 Prix Montaigne. His subsequent book, The Rat Line, spawned a BBC podcast of the same name. He will be speaking tonight on his experience of dealing with competing arguments about science in the context of litigation before the International Court of Justice. And on a personal note, I had an undergraduate student who became a student of Philippe's in New York. So we share a very talented young student. Now, before I hand over to Philippe, I will briefly outline the order of events. First of all, there is no fire alarm planned. They take place on Friday mornings, and this not being a Friday morning, there is no fire alarm. So if you hear it, then please all go out, and the muster point is at the top of Duke of York steps. Philippe will then speak on science law and the international courts, and at the end we'll have a Q&A session for approximately 20 minutes. Now, if you're viewing this online, please use the Slido link underneath the video display to submit your questions. Members of the in-person audience can also submit questions using Slido or wait and ask them in a more conventional manner at the end. Following the Q&A, there will be a drinks reception, and you're all very welcome, except those of you online, sorry about that, to attend the discussions. And now, without further ado, may I hand over to Philippe. Thank you.
Thank you very much. I'm just going to remember to switch off my telephone. It is off. Thank you very much, Julia, for the very kind words, and thank you also to Cara and the Royal Society, two organisations I know reasonably well. Cara, of course, I'm hugely supportive of, coming from precisely the same background on my mother's side that Cara has done so much work for, and the Royal Society, of course, has crossed my path in so many different ways. So it's really very wonderful to be here with this audience respecting, if you like, or reflecting both organisations. I'm going to take you on a somewhat personal journey that departs from areas that you may more typically associate me with in relation to crimes against humanity and genocide, although I'll come back and connect the two lives in due course. And I want to begin with a lecture that I gave 10 years ago at the Supreme Court in this country on climate change and the rule of law. I explained in the course of that lecture how 3 years earlier, in 2012, I'd been invited to attend a meeting of a small group of ambassadors at the United Nations in New York. And the context was an initiative by a group of small, low-lying island states. I'd often worked with those states back in the early 1990s, and in particular, the small country of Palau, which wanted to persuade the UN General Assembly to ask the International Court of Justice in The Hague to give an advisory opinion on the responsibilities of states under international law to ensure that activities carried out under their jurisdiction or control that emitted greenhouse gases did not harm other states or the environment. Are you in favour of such an initiative? I was asked in 2012. And I replied to the ambassadors that I was not, and I explained why. I doubted that the International Court of Justice, based in The Hague, the principal judicial organ of the United Nations, composed of 15 judges, could really give an advisory opinion that was helpful to the countries concerned or to the world as a whole. I worried, in fact, rather deeply that there was a serious risk that the court could actually offer an opinion that was unhelpful. It could, for example, decline to exercise jurisdiction, which would imply that international law had nothing to say on the subject, or it could give an opinion that was positively unhelpful, in particular, in relation to what it said about the state of the science. I told the ambassadors that it was possible that the court could give an answer that might elucidate the relevant rules of international law and be helpful on the science, and that such a contribution could theoretically generate greater political will. But as matters then stood in 2012, the negatives outweighed the positives. And that was based on my own experience before the International Court of Justice, dealing with various cases in which matters of the environment or disputed science came up to be determined. I suggested to the ambassadors concerned that they should probably not think about the International Court of Justice, but they might think about the International Tribunal for the Law of the Sea in Hamburg, which dealt with maritime matters. And that was how I left that conversation. 3 years passed. When I stood and spoke in the courtroom of the Supreme Court in September 2015, my perspective on the court's potential role had changed. It had evolved because of a number of factors that had occurred in the intervening period. There seemed to have been a change in public opinion. Even the Pope had very recently issued a strong encyclical letter framing the issue of climate change in moral terms. That was a first. More significantly, the scientific evidence appeared to a non-scientist like me, limited essentially to a biology and physics O-level, looked as though it was increasingly clear and robust. And significantly, countries were beginning to come together to take more actions. Even the United States and China had recently announced targets to cut greenhouse gas emissions over the next 10 to 15 years. And finally, and very significantly, national courts were beginning to act on cases relating to climate change. Just a few weeks before I spoke in the Supreme Court, the Rechtbank, a court in The Hague, ruled that the Dutch government's climate change policy was unlawful because it failed to achieve a 2020 greenhouse gas emission target reduction of 25 to 40%. And it based its ruling on the state of the scientific evidence against the background of a global commitment to reduce global greenhouse gases to a level in which global average temperatures were limited to rise no more than 2 degrees Celsius above pre-industrial levels. And I started to think, well, if all of these factors are coming together, if national courts in the Netherlands and perhaps elsewhere are beginning to grapple with the science in a way that could actually contribute to a change of consciousness, then maybe too an international court could make a useful contribution. In particular, a ruling from the International Court of Justice in The Hague could buttress the growing consensus on the scientific evidence as to human-induced climate change and be used to marginalize the naysayers and the deniers. And so, in that lecture for the first time, to the surprise of quite a few people, I said, actually, maybe the time is ripe, and the International Court of Justice could give a ruling on these kinds of issues. And I'm going to explain a little more about that context. The lecture attracted rather significant attention. Some of it was positive, but some of it was deeply and very personally negative. I'm quite a robust individual, so I don't mind that at all. A writer in the Daily Telegraph, who shall remain nameless, complained that a top QC was calling for an international ruling to scotch claims that challenged the scientific consensus on global warming. The Spectator raged about, and I quote, a scary plan to outlaw climate change, and worried that, quote, an imaginary problem, climate change, could soon have real consequences. Well, those real consequences have come to pass. On the 29th of March last year, the United Nations General Assembly, by a resolution adopted by consensus, it is the first time in the history of the United Nations that a request for an advisory opinion to the International Court of Justice has been adopted without a vote by consensus. That says quite a lot. Decided to send 2 questions to the International Court of Justice. A request for what is called an advisory opinion. First question, What are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? And second, what are the legal consequences under these obligations for states where, by their acts and omissions, they may have caused significant harm to the climate system and other parts of environment? That is the sound, in my world, of the rubber hitting the road in terms of environment, law, and science coming together. Because embedded at the heart of these two questions, and necessarily in the issues that the court will now have to address, is the question of the place and firmness of the scientific evidence on climate change. In April of this year, the court announced that 91 countries and international organizations had submitted written statements, 7 international organizations, 84 countries. That is double any previous case before the International Court of Justice. In August, the court announced that 62 written comments were filed in response to the first round of written statements. That too is a record by a long distance. 2 weeks ago, the court wrote to all the participants to indicate that the hearings would open in the Great Hall of Justice on the 2nd of December. And just last week, I am counsel for Mauritius, so we got the list, were told that 100 countries are participating. It is more than double any previous advisory opinion before the International Court of Justice. So something is going on. And science, I can tell you from the pleadings, which are not yet public, is at the very heart of the proceedings. The science will become available with the pleadings the day the hearings open on the 2nd of December, so just in a few weeks. The crucial question is, how might the court address the issues of science? How does an international court of 15 judges go about assessing scientific evidence? And what I want to share with you is my own experience following the journey that the court has taken over the last 20 years in addressing that question. And it will surprise you, I suspect, what the starting point was. Now, a word about the court. It's a first instance court. It's not an appeal court, and there are no appeals from its decisions. It is therefore frequently called upon to make findings of fact. And the cases that come before it frequently raise complex and hotly disputed issues of fact: the location of boundaries, the actions of a state in using military force, actions in relation to international crimes, and so on and so forth. The hearings are the culmination of a process that follows 2 rounds of written pleadings, and the pleadings will often include statements or affidavits from witnesses of facts, or even reports from scientists. The hearings may last from a few days to several weeks, but only very recently have they started, and rarely, to have live witness or expert testimony. The hearings in December will be tough for the judges. Every participating state will have 30 minutes to make its argument, and the poor judges will have to hear 10 countries each day for 10 days. Put yourself in their position. And of course, we're all grappling with the question of how do we stand out? How do we make it interesting for the judges? How do we keep them awake? I was once told by my very dear friend James Crawford, in the very first case I ever argued, which I'll come to in a moment, a contentious case, he said to me, "Philippe, you'll be doing incredibly well if the Russian and Chinese judges are both still awake after 20 minutes. It's not the most riveting of experiences." So my experience at the International Court of Justice began in the early 1990s. I was counsel for a group of small island Pacific states, actually in an advisory opinion request from the United Nations General Assembly, hotly contested, on the legality of the use of nuclear weapons. I was for a group of 4 countries that took the view that the use of nuclear weapons was unlawful in all circumstances. The International Court of Justice heard arguments from Samoa, Solomon Islands, Marshall Islands, Micronesia. We were the only ones to address the environmental aspects of the use of nuclear weapons. And I still remember the then Attorney General, Sir Nicholas Lisle, telling the court that James Crawford's arguments on environment were nonsense and Sands's arguments were dangerous nonsense. The point was, as recently as 1996, the court had never addressed an environmental issue. It seems incredible but true, and there is here a generational issue. I'm part of that generation that never studied environmental law at university. It wasn't on the syllabus. The relationship between science and law was not something that we were ever taught. I came across the subject by accident in the late 1980s when, with my dear friend James Cameron, who's here tonight, we co-founded with a couple of American colleagues an organization called the Center for International Environmental Law. And our first piece of work was on advising the small island states of the world on the issue of climate change. This was 1989. And we therefore had the privilege and the challenge of participating in the negotiations of the UN Framework Convention on Climate Change from 1990 to 1992. And that was really the moment where I came to understand the issues, but also came to recognize the vital importance of being incredibly well informed and brief on all aspects of the science that related to these issues. The Climate Change Convention was adopted in 1992, as you know, and the following year, the General Assembly requests this advisory opinion from the International Court of Justice. Astonishingly, by a majority, the court, for the first time, addressed the environment in its advisory opinion. At this very same moment, 94, 95, I was in a debate with a distinguished professor of public international law at Oxford, Sir Ian Brownlee. Why doesn't your textbook have anything to say about the environment on international law? And he said, because the International Court of Justice has never said anything. And if the International Court of Justice hasn't addressed it, it's not international law. Well, in this advisory opinion, the court said the environment, and I quote the exact words, the environment is not an abstraction, but represents the living space, the quality of life, and the very health of human beings, including generations unborn, and that the general obligation of states to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control, and then the key words, is now part of the corpus of international law relating to the environment, end of quote. And so with that moment, the environment moved onto the international legal stage in a very real way. It could no longer be said that the protection of the environment was not part of international law. Now, while that case was proceeding, another one had reached the International Court of Justice, and it really was the first case that dealt fully with a major environmental issue. It was a dispute between Hungary and Slovakia, and it was sent to the court in late 1993 by special agreement. It was a sort of hangover of the communist era where the Soviets had encouraged Hungary and Czechoslovakia, which then split into the Czech Republic and Slovakia, to construct a series of massive barrages on the Danube. In fact, there were two. One of the barrages was at a place called Gabčíkovo. The other barrage was at a place called Nagymaros. Now, for anyone in the room who knows about the Danube, you will know that the flow, it's a large river with a very large body of water, but the flow of the river is not fast because the slope is very gentle. And what that means is that in order to maximize the production of electricity, rather than having the barrages operate on a continual flow, the turbines, it's much more productive to stop and store the water at the barrage and open the sluice gates at times of maximum electricity demand, when a huge amount of water then rushes through. With the transformation in politics in Central and Eastern Europe, the protection of the Danube became a very significant organizing factor for the Hungarian opposition in the late 1980s. So that by the time the Soviet Union collapsed, the new Hungarian government including a very young Viktor Orban, who I met, was opposed to the barrage as a sort of Soviet-imposed construct. And the arguments that the Hungarians made was that there were two major environmental problems based on their scientific advice. Firstly, that by storing the water and stopping the continual flow on a stretch of about 100 kilometers, you took water out of the side arms of the River Danube and you would cause great damage to biodiversity. And secondly, by storing the water at each of the two barrages and allowing the pollutants, including heavy metals, to sink to the bottom of the river, they would enter the drinking water aquifers and supplies. Those were the two arguments that were made. Slovakia responded negatively. There's no scientific evidence to support that. Hungary terminated the treaty. Down tools stopped working. Slovakia implemented a unilateral solution. The reason you needed both countries involved in the construction of the barrage is that the Danube is a boundary river. What does Slovakia do? It diverts the water onto its own territory and operates a single barrage on its own territory, which Hungary says is in violation of international law. The matter goes to the International Court of Justice, and both sides retain scientists to make their arguments. And here is the first aspect that for me was very curious, because by then I'd been involved in a small number of cases in the domestic courts here in England, where scientific evidence was put forward in the form of an independent expert report, and the independent expert or experts would then be subjected to cross-examination and questioning by the judges. That is not what happens at the International Court of Justice. You need to understand that the practice at the International Court of Justice is rather like a theatrical performance. As counsel, you have a prepared speech and you simply stand up, deliver your speech for 30 minutes, 40 minutes, an hour, if they're still awake, and move on. And the decision was taken, because this was the first environmental case before the court, that both sides would not tender experts for cross-examination, but appoint scientists as counsel who would deliver speeches. And that was the way that it worked. The court had the possibility of appointing its own scientific experts in order to form a view on the two competing arguments. And for those of you who've been in court, you will understand the experience that I went through when you hear your own side's argument scientists make what you think is an incredibly compelling argument, and then you hear the other side's impeccable scientists make the counter-argument, and you think, wow, that's pretty compelling also. How do I, as a lawyer, form a view on the merits of those two competing and diametrically opposed arguments? It's a very complex question. Lawyers are not trained or equipped. They have no scientific background, the 15 who sit as judges. How on earth do they decide whether the threshold of ecological crisis, ecological emergency, a scientific harm rising above a threshold which permits a court to intervene and say, yes, Hungary is entitled to terminate, no, Slovakia is not entitled to build a unilateral solution to deal with this problem? It's a complex question. Both sides produced their scientific evidence. The hearing is closed after a few weeks. 6 months passed. The court then hands down a judgment. And the judgment concludes that Hungary had raised a justifiable argument. This was the first time in the history of the court that it accepted the concept of an ecological necessity to justify an action, but it failed to persuade the court that the harm or harms that it had predicted to occur would occur with absolute certainty. That was the standard they applied, and that allowed them to bypass the issue. How they formed that view is not set out in the judgment. 15 lawyers forming a view on two sets of competing arguments with no real basis explaining how they came to that view. But that's the view that they came to. They ruled that Hungary's actions were unlawful, they weren't allowed to terminate, and Slovakia had acted illegally by adopting a unilateral solution. I left that process, and you can begin to understand why in 2012, the judgment came in 1997, I was pretty sceptical about whether the court ought to be given the issue of climate change to address. And I thought this court really is not, I think, the place where you want to be dealing with big scientific and environmental issues. The next case that came along about 13 years later is called the pulp mills case. And that is a dispute between Argentina and Uruguay. Again, it concerned a river, the River Uruguay, which was protected by an international treaty between Argentina and Uruguay. Uruguay decided that it wanted to establish a series of pulp mills on its riverbank and use the water to cool the mills and discharge the ensuing pollutants from the manufacture of pulp to make paper, made from eucalyptus plants, into the river. It's a shared river, it's a boundary river. Argentina said, absolutely no way, we're not going to allow you to do this. And we wondered what the court would do in addressing the competing scientific arguments. Argentina marshaled impressive international scientists to make the claim that the discharge of this amount of pollutants into the river would have tremendous negative ecological and human consequences. Uruguay tendered equally compelling evidence to show the contrary. More to the point, the International Finance Corporation, an international organization based in Washington, D.C., had provided funding to Uruguay to support the construction of the two pulp mills. In fact, one was eventually abandoned, and they were left with a single pulp mill. And the IFC had an obligation to carry out an environmental impact assessment as regards the effects of a project it was funding, and that environmental impact assessment was relied upon by Uruguay to demonstrate that no less an organization part of the World Bank family as the International Finance Corporation had said this level of pollution was fine for the river. I have to say, as I was counsel for Argentina in that case, I'd been counsel for Hungary in the earlier case, I worried that with an IFC sign-off on the project, it was going to be pretty tough to persuade a number of judges at the International Court of Justice to rule that these pulp mills, or one pulp mill even, was going to discharge a significant level of pollutants into the river. And the reason for my concern was that by then, in another field in which I was involved, crimes against humanity and genocide, I had seen how the court, which was not well equipped to deal with competing factual testimony as to whether massacres had or not happened in a particular vicinity of former Yugoslavia, or whether the perpetrators of those massacres intended to destroy a group in whole or in part, such as to allow the conclusion that an act of genocide had happened. What the court did was rely on judgments of another international court, namely the International Criminal Tribunal for the former Yugoslavia, which had ruled a little earlier that the events at Srebrenica constituted a genocide. And that was exactly what the court did in Bosnia versus Serbia, a case about genocide under the Genocide Convention. It basically piggybacked off the decision of another international court. And the moment this case got up and running, you could see that the judges might be inclined to piggyback off the decision of the International Finance Corporation. In preparing that case, we, of course, were conscious of what had happened in the Gabčíkovo-Náši case, the Hungary-Slovakia case, and approached the registrar to ascertain how we should deal with the scientific evidence. And we asked, could we bring experts to court, have them subjected to examination, cross-examination, re-examination, and be available for questioning from the judges? And the registrar said, no, we don't want to do that. This is how we did it in the Gabčíkovo-Náši case, and we're going to do it in exactly the same way. Fast forward to the judgment in the pulp mills case in 2010, and the court does exactly what many of us predicted it would do. It relies on the decision of the International Finance Corporation to finance the project and produce an environmental impact assessment premised on a conclusion that the adverse effects were not so terrible, and it allowed the project to go ahead, although it found that Uruguay had violated some of its procedural obligations to provide sufficient information and consult with Argentina in relation to the plant. What was interesting, though, in this case, and it gave a hint of what was to come, was that some of the judges criticized the approach to dealing with science. And there were two critiques. One critique was that the two countries should not have proceeded by using scientists as counsel, but should have made them available as experts so that their expert evidence could be subject to testing, cross-examination, questioning by the judges. And the judges who complained about that, it turned out, as one discovers when you go to a cocktail party or something and speak to the judges who have complained about the way in which you've proceeded, and you then say, well, actually, we checked with the registrar, and this is what the registrar said we should do, the judges were unaware of that. There was a second critique, and that critique was that the court had, and this was a minority on the court had the power to appoint independent experts, scientific experts, to provide advice to the judges on the competing scientific arguments put respectively by Argentina and Uruguay, and it had failed to do so. And a number of judges severely criticized the failure of the court to have done that. I have to say, this was one of those cases where the scientific evidence, firstly, you learn a lot as a lawyer working on these kinds of cases that you are completely unaware of. We all had it proceeded on the assumption that when a river flows, it can flow only in one direction. But that's not actually what happens on the River Uruguay. Amazingly, the evidence that emerged in the course of the pleadings showed that the river actually flows in opposite directions at the same time. That you have a situation in which, it's difficult to comprehend, I'm looking at some of your faces here, but it can flow downstream and upstream at the same time, so that the upper part of the river is flowing downstream, and that is causing a reverse flow effect below the surface, so that the river is going in opposite directions. And the scientific evidence that the IFC had relied on and that Uruguay relied on demonstrated that that reverse flow factor had a dispersing effect in relation to the pollutants that Argentina had not taken full account of. Some of the judges said in their separate opinions that this needed further testing, and it should have been tested by independent experts appointed by the court, not relying on the parties. This, of course, is the civil law model to litigation. In the common law model, each side tenders its facts, each side put forward its experts, and then the poor judges have to decide between those competing views. In the civil law model, it is the judges who take the facts and the scientific evidence by the scruff of the neck and have the duty to find out where the truth lies or where the preponderance of evidence goes. So you see within a place like the International Court of Justice, some from a common law tradition, some from a civil law tradition, very different legal cultures pulling in different directions. One of the aspects of this case that was different from the Gabčíkovo case, so you begin to see the direction the court is taking, is that unlike the Gabčíkovo case, where there was not a single question in relation to any of the evidence posed by any of the judges, in the Pulp Mills case, some of the judges asked questions. You'll assume that when you're standing up there as counsel and a judge asks a question, you've got to respond straight away. No, that is not how it works. This is an international court. The sovereignty of the state must be respected. And basically, when a question comes, you then have a week to respond in writing. So for those of you who are lawyers in domestic courts, this is a pretty weird system that operates. But the fact that in 2 weeks of hearings there were 2 questions was completely thrilling, because it indicated that the judges were beginning to ramp up their sense of knowledge and of experience. The upshot was that the case effectively failed, and the court, in its judgment, as I've said, relied on the practice of the International Finance Corporation effectively in signing off on the project and dismissing the allegations of adverse scientific effects. That was the point at which I met the ambassadors and felt pretty skeptical about the prospects of the International Court of Justice doing something useful on climate change. And then along came the third case, where, for me at least, everything changed. And all of a sudden, for the first time, with a new generation of judges, you began to see that they were willing to roll up their sleeves and get their hands dirty with the muck of scientific evidence. It was fascinating to see the evolution. The case was brought by Australia against Japan, and it concerned, I'm putting this in quotes, scientific whaling in the Antarctic. The context was that since 1985, the International Whaling Commission, acting under the 1946 Convention, had banned all commercial whaling anywhere in the world. What was permitted still was artisanal whaling in Iceland or various other parts, or scientific whaling for purposes of science. And Japan developed 2 programs, JARPA 1 and JARPA 2, in which it would engage in the take of about 350 minke whales and about 50 fin whales and 50 humpback whales in the Antarctic. And it justified that program, known as JARPA 2, on the grounds that the take and the lethal take was necessary to carry out scientific investigations. The program of scientific investigations had 4 stated scientific purposes. First, to monitor the Antarctic ecosystems, including the abundance of whales, trends in their populations, biological parameters, krill abundance, and feeding ecology. A second objective, to construct a model of competition among different whale species. How do they interact? A third objective, changes in the temporal and spatial structure of stocks of fin, humpback, and minke whales. And objective number 4, to improve management procedures for Antarctic minke whale stocks. The beating heart of the case was whether these objectives and the practice of engaging in them amounted to the conduct of scientific research, which was not fully defined by the International Whaling Convention and the schedule attached to it. What the court had to decide was a very interesting and significant issue: what is scientific research? And I have to say, it was a complete privilege to be involved in such a case, because you were really going back to first principles to understand how you characterize certain activities and where is the line between commercial activity and scientific activity. It felt to me, because I often deal with the facts of the case, and this was dealt with as a factual issue, to make the arguments. And the arguments that I made on behalf of Australia was that the lethal take existed simply to allow whales to be killed and not to establish a genuine program of science. Because, and here we were much assisted by leading scientists from around the world, a genuine program would identify objectives for conservation and management based on broadly agreed research objectives based on testable hypotheses. And Japan had not identified any testable hypotheses. In reality, we said to the court, the objective is nothing more than monitoring, and monitoring is nothing more than the collection of body parts. The collection of body parts, in the views of the scientists retained by Australia, is not scientific research. The collection of data itself, Australia argued, cannot be considered as being for purposes of scientific research within the meaning of the convention and its schedule. And we went back, and at this point you could see in the room the judges were getting incredibly interested, realizing that for the first time they were going to have to descend into some rather complex issues about the definition of scientific research. And the argument which resonated most clearly with the judges was a reference to the work of a distinguished French scientist, Jules-Henri Poincaré, who in 1902 published a book called La Science et l'Hypothèse, which is still in print and treated as a classic more than a century later, available, as we told the judges, on Amazon, with a very lengthy introduction. You've got to remember, half the judges come from the common law world, half the judges come from the civil law world, and so if you're going to rely on a French scientist, you need to balance that by finding some sort of Anglo-Saxon type who can give legs to the argument. But fortunately, the introduction to Poincaré's book was written by Professor Larmor, the Lucasian professor of mathematics at the University of Cambridge. And that, I think, gave the argument legs with other judges, who commended Poincaré's text in his introduction and personally translated it for an English readership as a demonstration of what he called, and I quote, the French instinct for precision and lucid demonstration. End of quote. I should just pause here and say I am a dual national of France and the United Kingdom, so I particularly enjoy the balancing of these kinds of arguments. What does Professor Poincaré have to say, asks Professor Larmor, and I quote, and it's a brilliant quote, and it was the winning quote in the case. Science is built up of facts, as a house is built of stones. But an accumulation of facts is no more science than a heap of stones of a house. And when you're making arguments in a court of 15 people, very often there'll be a particular moment where a line emerges which the judges will then pick up on. And this then triggered a whole series of questions from the judges, as in no case I've ever experienced before or after, on the meaning of a hypothesis, the identification of a hypothesis. Ken Keith, for example, the New Zealand judge, asked a lengthy question about hypotheses. And I quote, Judge Keith said, "I was thinking if that young man who got on the Beagle and started gathering stones," it's a variation of the Poincaré quote, perhaps, "what do we know exactly about what Darwin had in mind as he started collecting all of his samples?" And that triggered more and more questions from the judges and responses from the scientists on both sides. The simple point was that, in a sense, on dealing with science, this was a moment where you felt an atmospheric change in the room. The judges were interested, they were completely on top of the evidence, and they had rolled up their sleeves and got their hands really dirty. The other thing that happened is that the move to scientists appearing as counsel was abandoned. And both sides now produce scientists for cross-examination and questioning by the judges. And that was a complete game changer. All of a sudden, you could see in the room issues coming up. And I'm going to give you a couple of examples. There was an expert tendered by Japan, an absolutely delightful Norwegian scientist. Of course, it won't have escaped you that Norway is one of the few countries that engages in whaling activity. Very decent person, independent, it seemed, of the Japanese state, and very candid, as you will hear in his answers. His name was Professor Wallow. And he was questioned by the Australian Solicitor General. Now, again, I've already hinted at this. In the International Court of Justice, it's not like being in a national court. The judges are appalled by aggressive examination of a witness, particularly if it's a scientist. They're very uncomfortable with that because the scientist is retained by the state, is in effect a representative of the state, even if independent. And so the advice James Crawford and I gave, in this case, we were for Australia, to Justin Gleeson, the Solicitor General, was, Justin, it's not Canberra, it's not Sydney, it's not Melbourne, it's the International Court of Justice in The Hague. Just go gently. Justin Gleeson is a fabulous cross-examiner, and he totally ignored the advice that we gave. We sat there in abject horror as he ripped into this Norwegian expert. Mr. Gleeson, apart from that inference, Professor Wallow, does the document you are showing us tell us what data is needed to build the model? Mr. Wallow, no, but I assume, Gleeson interrupts. Thank you. Could I now ask you the next question? If we are not told what data is needed for the model, does that mean that we do not have any statistical basis for knowing how many whales must be killed in order to build the model? Mr. Wallow, no, not necessarily, because there is a reference to a model here, which I know fairly well. In fact, it's an interesting model. Mr. Gleeson, well, you say that you've repeated some calculations for a few variables, making assumptions, and you believe that the results in the JARPA-2 program are of the right order of magnitude. Why didn't you include those calculations in your report so that the court and Australia could consider them? Mr. Wallow, the reason is, and that's one of the reasons as I state here, it's really the weaknesses of the whole JARPA-2 document. I do not really know how they, the Japanese, have calculated the sample sizes. 350 minke whales, 50 fin whales, 50 humbags. I have to make guesses, and that's what I state. Somewhere here I write that the explanation is not always clear. I mean, that's my criticism of the JARPA 2 program. I had to make a number of assumptions which may or may not agree with what the Japanese scientists have done, but the basic is if you could detect changes over a 6-year period, and of course a 6-year period that they've chosen is arbitrary, you could equally choose a 12-year period. And this was the moment, under a very tough cross-examination and followed by subsequent questioning from the judges, that the argument for the JARPA 2 program as scientific research collapsed under proper scrutiny guided by the court. In March 2014, the court issued its judgment and ruled in favour of Australia. What Japan was engaged in could not be characterised as scientific whaling because it had not explained why it needed a lethal take to justify the actions it wished to take. And it effectively, in its judgment, accepted the Poincaré argument that the mere collection of data is not such as to characterise that activity as scientific research. So in the space of about 15 years, you begin to see the move that the International Court of Justice has made. And that judgment came just before I gave the lecture in the Supreme Court, which meant that I, for the first time, felt not completely comfortable, but more comfortable that this international court was a place to which one could imagine the entrusting of scientific evidence. So to conclude, let's come back to what the court is going to have to address. I don't here need to repeat to you the status of the scientific work that has been done by the Intergovernmental Panel on Climate Change, which is predicting, without a strengthening of policies, that greenhouse gas emissions are projected to rise, leading to a median global warming of 3.2 degrees Celsius by 2100. And the IPCC tells us that that is catastrophic for human existence in many parts of this planet. For the Mauritius team, actually, we went and retained the services of Professor James Hansen to give us an independent view on the science. And in his export report, which Mauritius filed before the court, he concluded, and I quote, "The situation is urgent. More delay will elicit additional warming, amplified risk for natural and human ecosystems, and increased likelihood of crossing tipping points in the global system." End of quote. In addressing the two questions put to it, the court is going to have to form a view on the state of the scientific evidence. You can't form a view as to what the responsibilities of a state are without forming a view as to what the law requires them to do against the background of the consequences of their own actions in continuing to emit greenhouse gases at levels which the scientists appear to be saying is likely to be catastrophic. And it's been very interesting to read the 100 or so pleadings that have been put in and how the science is dealt with. In the meantime, it's important also to mention that there's been another advisory opinion from the International Tribunal for the Law of the Sea, which is limited to the protection of the oceans, so a much more limited exercise than the International Court of Justice, which is looking at climate change in the round. And the International Tribunal for the Law of the Sea had quite a lot to say about science. My own view is that it didn't go as far or was as clear as was needed. It concluded, for example, and I quote, "The science undoubtedly plays a crucial role," end of quote. And throughout the advisory opinion, the International Tribunal for the Law of the Sea took account of scientific evidence of a high risk, as it put it, that outcomes will be even worse if the 1.5 degrees Celsius target, which states are now bound to meet, is not met. And the International Tribunal for the Law of the Sea made the connection between the standard of acting with due diligence in going forward and the status of the scientific evidence. But the court, the Tribunal for the Law of the Sea, didn't say that the science is now reasonably certain and clear, or that there is a consensus on the science. And I think that's one of the very important things that the International Court of Justice can do in finding the nexus between climate science and the law, in interpreting and applying the relevant international legal instruments that it will have to interpret and apply. I can't tell you what the states that are participating have said precisely, because the material is not yet publicly available, and I want to respect the confidentiality. I'll simply paraphrase broadly. The vast majority of participants have recognized that the science plays an absolutely central role in determining the content and effect of certain legal obligations. But a small number of participants, some of them very significant countries, have invited the court to answer the General Assembly's legal questions in a legal vacuum, in a scientific vacuum. Please don't express a view on the science in reaching your conclusions, which is in effect a way of saying, don't answer the questions. It's very hard to see what reasonable answers can be given without forming a view on the science. So what's the significance of science in the questions that are coming, and what are we looking out for when the hearings open in December in relation to these two questions? What are the obligations of states, and what are the legal consequences of failing to meet those obligations? I think the first aspect is what the court says on the science at the international level can have a very significant trickle-down effect in allowing national courts, which is where the rubber is going to hit the road, to form a view on domestic cases. And that's particularly the situation in countries where global warming denial or related matters is still very, very strong. We know, for example, there is a candidate in the coming US presidential election who in 2012 stated that the concept of global warming was created by and for the Chinese in order to make US manufacturing non-competitive. He has not retracted that view. In 2018, he said, I don't know that global warming is man-made. Last Wednesday, he had an opportunity to come back on what he'd said previously, and he failed to do so. In 2022, he called climate change a hoax, and in December 2023, he called it a giant con job, and on the 3rd of September 2024, he said it's time to call it global cooling, because there's as much evidence that the planet is going to cool in nature. So I think what the International Court of Justice can do by giving a robust view on the state of the science, and not just saying it's important in forming conclusions on the law, is assist national courts, and there are plenty of cases around the United States now, which are dealing with the consequences of global warming, climate change, could be used to help knock those cases on the head. Second function of the science, and I think what I hope the International Court of Justice says, more clearly than the International Tribunal for the Law of the Sea says, is what are the consequences of failing to adopt actions that are based on the scientific evidence, and in particular, opening the door to claims that you are not acting with due diligence. And the court's advisory opinion, a court advisory opinion which made a clear statement as to what the state of the scientific evidence is and what the consequences of continuing on pathways would be, opens the door to future arguments about the responsibilities of states for those consequences and the responsibility under criminal law of individuals for ignoring the scientific evidence and proceeding. Third aspect in which I think the science is important is dealing with the historical and temporal element. We are where we are today because of anthropogenic emissions that go back 200 or more years. What that means, in application of a principle that's embedded in the UN Framework Convention on Climate Change, a principle known as the common but differentiated responsibility, is that every state today has a responsibility to act, but the burden on different states will depend on their historic contributions. And I think the court can help us by confirming the state of science on historic contributions. On all of these points, they've had arguments from parties that are appearing before them. And I think the court can also deal with some other domestic kinds of issues. I was surprised to read an article by the Prime Minister of this country in the Sun newspaper on the 3rd of October 2024. He wrote, "We're firing the gun on a record investment, our biggest so far, that will pull carbon out of the air and bury it safely underground. This groundbreaking technology, known as carbon capture, usage and storage, is a game changer in our efforts to fulfill our legal obligations to reach net zero by 2050 in a sensible way while supporting jobs and industry." End of quote. I mean, the technology that captures carbon emissions, I think many people in the room will understand, is not well developed. And it would be helpful for the court to express a view on some of these ideas in identifying the nature and extent of obligations of states. Some of you will have read in the press that heads of government and heads of state of Commonwealth are meeting right now in Samoa, and one of the issues they're addressing, although the British government doesn't seem quite comfortable addressing it, is the question of historic responsibilities and assisting smaller and less developed countries in addressing the consequences of climate change going forward. Those arguments will be informed by what the International Court of Justice might say on the science. And the fifth and final aspect, and it just dovetails in a sense with work that I've been doing in another direction that draws from a separate part of my life working on laws relating to crimes against humanity and genocide, is in relation to an emerging international crime called ecocide. There are currently 4 international crimes that exist on the international statute books. War crimes, targeting civilians during war. Crimes against humanity, targeting civilians on a widespread and systematic scale. Genocide, targeting groups, and the crime of aggression, waging a manifestly illegal war. All 4 of those crimes relate, for very understandable reasons, to the protection of the human. There is no international crime which deals with the protection of the environment as such. I co-chaired with a colleague from Senegal a working group of about 12 people from around the world, which a couple of years ago produced a proposal to add a 5th international crime to the statute of the International Criminal Court, ecocide, which focuses on the protection of the environment. Ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. any future case in relation to ecocide is going to depend on a number of factors. One of those factors is the state of an individual's knowledge, and that knowledge is dependent on the state of evidence of the science. When we did our work, finished it a couple of years ago, the press asked us very understandably to give examples of the kinds of things that we might consider to be ecocide. And we, I think, wisely did not produce a list and wisely declined to respond to those requests, recognizing that the moment you identify particular activities as likely to fall within an ecocide narrative, you have opponents, and it will be much more difficult to persuade states to move in the direction of a less anthropocentric approach to the law and a greater ecocentric approach to the law. And in a sense, that's the journey I've been describing to you. A court that was immensely skeptical 20 years ago only introduced the environment into its own jurisprudence in 1996, slowly coming to terms with the reality that we are not, as humans, masters of our universe, and there are forces at play that are bigger and more powerful than us. And the question that we have is whether we can reconceive our legal order, assisted not only by lawyers, but scientists in the proceedings that are coming up before the International Court of Justice, to underscore the importance of protecting our natural world, our environmental world, in the legal order itself, and making the protection of the environment an end in itself, not merely something to protect the well-being of humans. And in that regard, I'm going to finish by commending to you the best law review article I've ever read, still today, after about 40 years in the law, published in 1972 by a marvelous individual called Christopher Stone, a professor at the University of Southern California. You'll find the article, the original PDF, on the web, Should Trees Have Standing, which reconceives the role of the law and is premised, as much of Christopher Stone's work was, on giving greater weight in the construction and design of our legal order at the national level, and as he wrote later in another book, The Gnat is Older Than Man, at the international level, a greater weight to ecological objectives as an end in themselves, premised on the kind of scientific understanding that has been put before the court in recent years, with mixed results, but taking a trajectory which allows at least some grounds for optimism. Many years ago, in a case before the House of Lords, Lord Atkin, a judge of the Judicial Committee of the House of Lords, noted that in England, amidst the clash of arms, the laws are not silent. And I think we need to reconceive that notion and recognize that the same principle exists in relation to the clash of scientific arguments and environmental arguments. Thank you very much.
Thank you very much, Philippe. I'm going to come over here to the microphones, but don't go away. That was absolutely wonderful. And I've read a couple of your books about East, West Street and others that make some quite arcane and esoteric points of law utterly gripping. And I'm sure many of you who've read Philippe's books will know that that's true. And you've done exactly the same this evening. The quite esoteric area of environmental law and science, that was just gripping. It was a fantastic presentation. Thank you very much. My name is Nicola Dandridge, and I'm the chair of Cara, and it is my role to coordinate the next 10-15 minutes or so with questions and answers. And we're going to do that partly from you, and also some people are going to be submitting some Slido questions if they're not participating in the room. So what I suggest we do is take 2 questions from the audience, and then we'll see what electronic questions we get thrown up. So Philip, you stay here. Can I just see whether you can put your hands up and we can take a couple of questions from the audience. There's a question, there's 2 questions, one at the back and the woman over here in the brown jumper. And Poppy's just bringing a microphone.
Thank you very much for that. I could just second what's just been said for somebody who doesn't come from law at all. What I was wondering about is, first of all, holding to account. So beyond those 2 questions, hopefully they are answered using scientists or about science, but about holding to account, and also what happens in terms of war. Does all that become suspended? Pointing to what you said earlier about nuclear arms, and perhaps in terms of ecocide, that is a no-brainer.
Thank you. Is there another question? Question at the back.
Thank you. Is there a danger that you reduce the exceptional threat of climate change and the existential threat of it by framing it within environmental law?
They're both excellent questions. So arguing against myself, my concern about the ICJ advisory opinion route is it creates the impression that we're doing something and that the issues are being addressed, and it's premised on an assumption that the law is actually capable of dealing with these issues. That concern is amplified by something I spoke of in positive terms, namely the fact that the request for the advisory opinion was adopted by consensus, something that has never happened before in any advisory opinion case ever before the International Court of Justice. Does that indicate and send a signal to the judges that a vast array of countries, the most deeply and highly threatened at one end of the spectrum and the most dependent on fossil fuel production at the other end of the spectrum, are equally comfortable with the question being sent to the court? And does the court respond, if you like, to all of the states? There is an argument that with a consensual advisory opinion request, the court will somehow feel compelled to give an answer that is acceptable to the totality of the membership of the United Nations, and that it would replicate the quasi-paralysis of the international legislative order, in which states seem unable to do that which is really necessary to deal with climate change, which is a very quick phase out of fossil fuels. In the face of that legislative failure, are we about to see it mirrored by a judicial failure? And I think, to answer that question, you've got to put yourself in the position of the judges. It's not the function of judges to legislate. And one of the challenges that I think the judges will have is to recognize, on the one hand, that states, through legislative process, have been willing to go so far but no further. What authority do they have to go further? And that, in a sense, is why my instinct is that the judges may assist more by focusing not on what the legal obligations are, but what the evidence, what the facts are. I was disappointed by the ITLOS advisory opinion because it didn't really do that. And will these 15 judges at the International Court of Justice be able to do it? I really don't know. I'm not wildly pessimistic. I'm not wildly optimistic. The only thing that I would say is that the story that I've told you today indicates that when they want to get a grip on the science, they are capable of doing it. And that is, I think, what you want to be watching out for in relation to what happens. But I understand the question, and I have a certain anxiety in that direction. On holding to account, it's really part of the same question, actually, because in essence, holding to account can happen at two different levels. It can happen at the state level, holding to account those states that are responsible for the largest volume of emissions over the last 200 years, perhaps on a per capita basis, in which case the United Kingdom comes out not smelling of roses. And that imposes significant obligations and burdens. And holding to account means all of us. And this was something that we grappled with in the work that we did on ecocide. If ecocide is to touch on the issue of climate change, as it surely must, in a sense, we're all ecocidaires. All of us contribute. How do you begin in a coherent way to draw a line which says, or which distinguishes between ordinary day-to-day human activity, driving your car, emitting greenhouse gases because you superheat your home or whatever, on the one hand, and a decision to authorize a new coal-fired power plant or a coal field in the United Kingdom, which the previous government did, and which to my mind is arguably an ecocidal act. I think the days when the United Kingdom can engage in fossil fuel exploration and exploitation are over, and that a prime minister who authorises that and a cabinet that authorises that, in my view, arguably is crossing a line into ecocidal behaviour. But these are really big questions. And the legislative process in terms of holding to account states or individuals is going to blink, frankly, because in the process at the ICJ, states appear before the International Court of Justice, and the kinds of arguments that they're going to make are not the kinds of arguments that are going to have massive impacts for themselves individually or for the states which they are responsible for, governing. Coincidentally, it's actually sort of interesting, the opening of the climate change arguments on the 2nd of December in The Hague coincides with the meeting of the Assemblies of State Parties to the International Criminal Court. And on the 9th of December, whilst the ICJ advisory opinion hearings are going on, the Assembly of State Parties will for the first time address the question of whether to amend the statute of the International Criminal Court to include a fifth crime of ecocide. So the issue of accountability is there, but it is one that makes people extremely nervous. And it's embedded in the court's second question. War does not suspend your obligations in relation to climate change or anything else. But as those of you who've been following what's going on in Ukraine and Gaza and Lebanon and Israel will know, the environment has been used as a weapon of war or has suffered very directly as a consequence of military activities. And international humanitarian law, the laws of war, really doesn't come to grips with environmental harm. And that's one of the reasons I think it's necessary to add a fifth crime, which looks at the well-being of the environment and the natural world, as well as human beings in times of war and at all other times. So the accountability issue is now being seriously debated, but I wouldn't hold your breath in terms of massive developments, immediately at least. I mean, my experience with international law is that it's only when absolute disaster strikes that the law changes and responds. I mean, we are capable of doing it. As the ozone, as the hole in the ozone layer emerged, states acted under the Montreal Protocol and took steps to ban completely certain substances from being emitted into the atmosphere. So it's not that we are incapable of protecting the environment or protecting ourselves. It's basically about political will.
Thank you. Poppy, do we have any Slido questions? Yes, we do.
Okay, so we have one here. Dear Philippe, what do you think about the ecocide that Russia is doing in Ukraine now? Does Ukraine have any chance to prove that war crime and win the case against the aggressor in the international courts?
So Ukraine actually is one of the first countries in the world to have a law on ecocide. It's a slightly different definition from the one our working group came up with, but they have charged Russia with environmental crimes, and you're aware of some of the things that have happened. I mean, I'm not expressing a view on any particular act because I'm not on the ground. I don't know why that barrage was destroyed, who destroyed it, but the evidence that appears to be pretty strong indicates that it was targeted by Russia with a view to causing maximum environmental harm, and it did. And Russia has charged that as a crime of ecocide under its domestic law. There is no crime of ecocide under international law, but there is a crime of using the environment as a method and means of warfare. I don't know whether the ICC prosecutor is looking into that particular act, but on the basis of what is publicly available and what I know, I hope that he is. So I think there is a big debate on ecocide in relation to Russia, in relation to Sudan, in relation to Gaza.
We have time for one very quick further question, if anyone has one. There is a hand up here, but I know we have to wrap up by 7:30, so...
Thank you. This has been really illuminating and interesting. I wanted to follow up on carbon capture and storage. I was interested to see that it got a very skeptical kind of reception in your lecture. And I was especially interested given that, as I understand it, the Climate Change Committee, the IPCC, many scientific bodies have said that this is, as I understand it, like an essential thing for us to be doing alongside steep emission reductions in other ways. So I was just interested to understand your view on whether that's a misinterpretation on my part, noting that that, of course, is kind of the future of many different governments. And also this tricky thing about people who do care about climate change deeply, but are getting many different mixed messages of whether something is scientifically imperative or not, and how to kind of navigate that. Thank you.
I'm so sorry, Philippe. You're going to have to try and answer that question in a minute.
I mean, in an ideal world, it's fantastically attractive. The idea that we can develop a technology which sucks the carbon out of the atmosphere or removes it at the point in which it is being introduced. But to the best of my knowledge, that remains theoretical work. And the quantities that would have to be removed are not yet the subject of plausible examples of a human capacity to do that. I know some of the people who are working on those projects, and they're really decent, incredibly well-intentioned folks. The difficulty is that the time that we have is now so limited that absolutely that work should continue, but I don't think we should premise any of our responses to the possibility that at some point in the future we may develop the technology to do that. We may well be able to. States are pushing for that in large part because they would like to avoid the alternative, which is basically phasing out fossil fuels completely. Oil, gas, coal, which has huge implications for industrialized societies. So if you're picking up a hint of skepticism, it's not at the theoretical idea, it's at its practical implementation in a time frame that could actually make a difference. And I think for a prime minister to put carbon capture at the heart of a strategy would be sort of misleading in terms of what we are capable of doing right now or what we are likely to be capable of doing in the foreseeable future. And I think it's a little bit misleading. I'm sure in a well-intentioned way that is intended to reassure people about what we can do. But everything that I know about that technology, and I do sort of follow it, does not indicate to me that we are on the cusp of addressing emissions of greenhouse gases through carbon capture. In terms of mixed messages, yeah, I mean, there are, those still in this country who say it's not happening, and you're a grown-up, you'll form your own view, you'll read yourself into the science. I've got to say, from what I know, talking to scientists, I've got no doubt. And I'm involved in a lot of horrible things around the world, in Russia, Israel, Gaza, Sudan, the Rohingya. I can tell you that top of my agenda, in terms of the most serious things we should be thinking about, is climate change. Because the consequences of climate change are going to make these appalling things we're witnessing now just pale into nothingness and insignificance compared to what is coming. So, I read everything that I can, and I worry deeply about our failure to have addressed climate change. I mean, James, who's in the back of the room, and I were in Geneva in 1990, in September, at the Second World Climate Conference. And we witnessed Margaret Thatcher give a speech saying, speaking not only as Prime Minister, it was her last international outing, but speaking as a scientist, as a chemist, someone who understood, saying, this is real, this is happening, we have to do something about it. 34 years have passed. We have not done nothing, but we have plainly not done enough. And we still don't have the political will to do what is necessary. And for those of you who have children or grandchildren, you will understand that this issue is now embedded in their existence as something that they think about. And my generation has let down those succeeding generations. We have an absolute responsibility to get to grips with this issue and recognize that where we have failed, we need to do more. This is an existential issue as far as I'm concerned. And I followed the science for 34 years, and they talked about carbon capture in 1991 and 1992, and they talked about economic instruments, and they talked about lots of other fancy things and technologies and scientific quick fixes. Nothing has been able to address the reality that it is all about stopping burning fossil fuels. It's as simple as that. We haven't done it in the last 34 years. I don't see on the signs that we're going to do it in the next 34 years. Sorry to be ending on a pessimistic note, but it's really serious, the situation. And coming back to the question about what the ICJ is doing, I think the challenge, I'm thinking, what do I say when I stand up before the ICJ on the morning of Monday, the 9th of December? We have 30 minutes to address the 15 judges. I know the judges. I know they will listen seriously. I know they take it very seriously. What is a judge to do faced with the inaction of states? And that's, in a sense, the challenge for an advocate in those 30 minutes. But it's not immediately apparent what it is that you can say to them that is going to cause them to go that bit further that could really make a difference. That's the challenge.
On which incredibly sobering note, we are unfortunately going to have to wrap up because we're out of time. And I'm going to hand over at this point to my colleague Stephen Wordsworth, who's director of Cara.
Thank you very much, Philippe. My role here was to give a vote of thanks. Nicola rather did that when she came on stage. But let me say, on my part, I'm sure that nobody here in this room, unlike the Russian and Chinese judges, fell asleep. That was a fascinating account. We're all aware of the dangers of climate change, the importance of environmental protection. I'm sure many of us have some understanding of international courts, but the interplay between those different things was new to me. I'm glad this has been recorded. In a few days' time, it should be on our website and on the Royal Society's website, so those who wish to do so can go through it all again, maybe more than once, and to pick up all the information from there. It's fascinating. So a very warm thanks to you. Very warm thanks also to the Royal Society for hosting this event. As Julie Maxson said at the beginning, our relationship goes back a long way. Our founding statement was rather grandly headed "From the Rooms of the Royal Society," that is in 1933, then in Burlington House, not here obviously, but we've had a very good relationship since then, which we wish to continue because we can work together and achieve things in the sense of academic freedom and campaigning for that. You mentioned also, Philippe, you've dealt with some pretty ghastly themes from time to time in difficult places. That's what we do, sadly. Since 1933, we've been working to help, protect, rescue academics who are in very bad places or suffering from very bad things, persecution, discrimination of all sorts, and get them to safety. We do that with the support of a network of the great majority of universities here in the UK, 135 altogether. We've been doing it. We're now busier than we have been since the 1930s. Our applications to us in the last 3 years are up almost 400% compared to the 3 years before, which just mirrors, it just reflects the impact of the crises in Afghanistan, Ukraine, Sudan, and now, of course, Gaza, as well as all the other places where people are at risk for saying what they think or writing what they think and speaking out, just being awkward or just need to get away from violence and conflict. We are there for them with all our partners. Once again, a big thanks to the Royal Society for hosting this event and for other work we do together. And you can now all go and get a drink. Thank you.